All right, good. Let's get started. Good afternoon, everyone. I'm Ray Glazer, Executive Director at IHFRA, and I want to thank each of you for signing up for the first of two webinars that's going to feature critical information from members of the team of Schoenberg, Finkel, Beederman, Bell, and Glazer, IHFRA's esteemed, and I do mean esteemed, legal counsel. As part of our goal of making each member as successful as possible, we know that education and information are the keys that truly can unlock that door to success. I'm here today with Steve Glazer, IHFRA's Director of Digital Strategies and Marketing. And Steve, would you please do the honors of introducing our presenters today?
Yeah, of course. First of all, thank you for the introduction. As Ray said, we're thrilled to be here today. Today, we're fortunate to have Adam Glazer, a partner at the firm, along with two of his associates, Matt Tyrell and Andrew Bell. Their firm is a nationally recognized full-service business law firm that has been helping clients since 1946. We're going to be covering several topics today. There's Andrew. Go ahead and get him in there. Those topics will include dealing with factories' come-to-market demands, health and safety issues for those of us who are traveling to market, businesses reopening and return to work best practices, applying for PPP loan forgiveness, changing tax laws, and so much more. Adam and his team have really put together just a ton of great information. So with that, I'm going to turn it over to them. First, again, Adam, thank you so much for being here. Thank you, Andrew and Matt. And Adam, I'll turn it over to you.
Okay, Steve, thank you very kindly. Thanks for the introduction. Ray, thank you as well. I and my colleagues, Matt and Andrew, who you're going to meet momentarily, are looking forward to not only sharing some thoughts with you about these topics, but also to taking your questions and engaging in a full, meaningful dialogue this afternoon. We have a number of topics, as you saw, that were published by IHFRA, both for today and for session 2 next month. But even without telling Matt and Andrew, who are going to be doing most of the discussion today in advance, I don't think I want you to feel limited to those topics. Andrew is a tax lawyer, Matt is an employment lawyer, and they can take questions that vary from those topics. Feel free as they are speaking to weigh in on the chat room, or after the fact, we'll take additional questions, and both Matt and Andrew will keep track best they can, and we'll make sure we cover them. But I know that questions, you begin the session today with some questions, you wait to see whether we answer them. If we don't, feel free to jump on the chat, or if additional questions come to mind and we inspire other areas, feel free. I will largely be covering the second session. So if you don't get scared off today and you come back next month and join me for the topics in the second session, largely dealing with commission recovery methods and how to proceed with getting paid from your principals, that will mostly be the subject matter for next month. For today, as you see, we're going to be dealing with some financial issues and also some employment related issues. I think they're very interesting topics. I think Matt and Andrew are going to cover them very well for us today. I just want to add to what Steve already mentioned. While my law firm is, and we market ourselves, of course, as a full service business law firm, we do have a lot of experience. We're one of the few firms around the country with developed experience with sales reps. We have been defending the interests of sales reps for decades. And that includes really providing a full service operation for sales reps, from the incorporation or from the development of a sales rep, from the merger, the acquisition, all the way through to the opposite end, to succession planning and to the decision perhaps to pass on a rep business. We cover all of that. We do a lot of tax work in connection with those transactions. And of course, we also do contract review, contract negotiation. And should anything happen pursuant to the contract, we cover that as well. I know in this business, most of us deal with oral contracts, and that's okay. It's they're oftentimes better than a bad written contract. So we're not afraid of a handshake deal, an oral agreement. It's something we're quite used to. So I don't want to take up too much more time. I want to get this process rolling. We're going to begin with Andrew and his discussion about certain tax law issues that he has covered. He has spoken on this before, including some relatively recent changes in the tax laws. So I want to invite Andrew to jump in here and hopefully generate some additional questions for you folks on topics that are undoubtedly of interest, including some pandemic-related issues. Andrew, go ahead, take it away, please.
Okay, Adam, first of all, can you hear me okay?
We hear you great.
Oh, great. Okay. So the discussion is broken up really into two parts, changing tax laws or new tax laws, and then PPP loans with a focus on forgiveness. I guess, fortunately, from my perspective, they dovetail nicely. The most recent pertinent change in tax laws has been the IRS's position that the expenses that you receive, that you used PPP loans for, that were subsequently forgiven, those expenses could not be subsequently deducted by you. So your payroll that you use PPP for, your rent expense, mortgage expense, etc., you can't double dip. Is probably the easiest way to say that. That does not mean that Congress is forbidden from changing that perspective, and indeed that's being debated right now. I gave this a similar discussion about a month ago. It's still up in the air. They may decide that small businesses need an additional shot in the arm, and you may be able to deduct the expenses that you received forgivable loan proceeds for. I would definitely, no matter what your course is here, I would suggest meeting with your accountants and your bookkeepers to make sure you have great records in terms of what you used your PPP proceeds for, because certainly come tax time, you'll need to submit those to the IRS, and of course you'll need them obviously for loan forgiveness, which I'll discuss in a little bit. I think the other thing that's pertinent is the fact that it is an election year, going on about 4 weeks out from Election Day. This is not a political discussion, it's just a statement. The expectation would be that if you have a Democratic win in the White House and in the Senate, one of the high priority items is going to be a reduction in the current state tax exemption from 11, well, it's really 10 million indexed for inflation, down to possibly the prior $5 million indexed for inflation or even lower. Where that's relevant for this audience is that folks that are trying to pass their businesses on to the next generation often use that exemption to gift to family members. And you may be in a use it or lose it situation in 2020 and probably 2021. So if you're considering those transactions and you have a Joe Biden win, you may need to accelerate your plans. If there's a Biden win, I wouldn't expect a lot of lame duck administrative procedures to go through because they could be overturned in a blink of an eye. If you see a Trump victory, I would anticipate them staying the course with their current Tax Cuts and Jobs Act, with the current low corporate tax rate, so on and so forth. One thing I would also like to point out as part of the Coronavirus Relief Act, the CARES Act, and the subsequent relief provisions is that there's an option for you to defer the payroll tax portion, the FICA withholding for your employees, but they'd have to pay it back in 2021 and in 2022. I just want to make clear that that is not a forgivable, put money in the employee's hands now and forgive it later. That would result in smaller paychecks in 2021 and possibly 2022. Just want to make sure that was clear. I'm also going to just double check. Okay, no questions yet. If you have questions, shoot them over to me. Happy to discuss them live. I think the turning now to the PPP forgiveness, because I think that's on the forefront of a lot of folks' minds. A couple of things to note. First, you have to apply within 10 months of the end of your covered period. Your covered period is generally going to be 24 weeks from the date you received your disbursement. So if you received it June 1st, count 24 weeks out from that. And then you have 10 months from the end of that 24 weeks to make your application. What's making things, I think, a little confusing for small businesses is that you actually don't apply to the SBA for forgiveness. You actually apply to your lender. Your lender then gives it an initial review. And if they approve it, they submit it to the SBA for approval. If they deny it, you then have 30 days from the date of the denial, they being the lender, to appeal the SBA. And if your lender first approves it, sends it to the SBA, SBA denies it, you then again have 30 days to appeal the SBA's decision. Seems straightforward. There is a quirk, and that is if your lender denies in part and grants in part your forgiveness, and then the SBA approves the denial and grant, there are no appeal rights, none. So for that reason, anyone that comes to us just generally, you want to make sure that that forgiveness application is, I mean, you have your T's crossed and your I's dotted. You may only get one bite at that. The other thing to note, your lender is going to be the one that provides an application. There is a template SBA application that has been out for a couple of months. Doesn't guarantee your lender is going to use that. So contact your lender and make sure you discuss with them their terms or conditions. If you have a friendly banker, you may be able to even submit a hey, here's the information. Are we missing anything? A good dialogue with your lender is, I think, essential at this point, because you may really only have one chance. I think most folks know, but in case you don't, the thresholds are you have to have spent at least 60% of your PPP loan on payroll. And the rest has to be the qualified expenses, which are generally, your rent, mortgage expense. I think most folks that have applied for the PPP loans are aware of those, but it was going to be 75% payroll. They dropped it to 60 because they realized it was a little too onerous. And also, if you got your loan early before June of 2020, your covered period, the time where you could use the proceeds, was only 8 weeks. You have the option to extend that over 24, unless there's a compelling reason why you would want to keep it to 8 weeks. You do have the option to extend it out. So again, 24 weeks from when you get your loan to use it, 10 months after your last day to use it to apply for forgiveness. And again, we're monitoring. I know there are several bills that have been passed back and forth between the Senate and the House. There has not been, at least as of this morning, I checked, there has not been any agreement on additional coronavirus relief. And so that's where we stand today. In an election year, it's a little difficult to forecast too many tax changes, but that's where we stand today. Do you have any questions? Someone said I did a great job. Thank you. I appreciate that. Adam, do you have any? Were there any questions submitted before the discussion that I should address?
Well, Andrew, here, I mean, as you're talking, a question comes to my mind about this. Based on your experience, what are you hearing, or what do you have an expectation in terms of the government's approach to forgiveness? Is this going to be a blank check once the lender gives it a stamp of approval, or is the government, do you expect, going to take a tough line and highly scrutinize these to try to avoid forgiving all of these applications?
Okay, I'm going to qualify my response, as any good lawyer will, with "it depends." The general rule of thumb. So I'm a tax attorney. I deal with the IRS. The bigger your dollar amount involved, the more likely it is to draw eyes. Regardless of the amount, if you took over $2 million in PPP loans, the SBA has to do an internal audit of your documentation. They have the right to review any application that comes through. The more information you can provide, the more detailed you are. I think this is just a general term when dealing with the government, you stand a better chance of passing muster. So your best practice would have been, I think, to take your PPP proceeds, open up a separate bank account, and then as you're paying expense, you're running it through your payroll company or whatever, you're transferring funds and you can earmark them. If you didn't do that, it's not the end of the world. You have this time to work with your bookkeeper, work through your accountant, work with your payroll processor to create those records. Each lender is probably going to be a little different in terms of the application, but really what they're looking at is how much money did you receive? How many employees did you have? How much of your money did go to those employees' salaries? Okay. And they're also going to look at your total, your payroll in terms of numbers of employees. One thing I neglected to mention, I apologize. You need to have the same number of employees by the end of 2020 as you did as of February 15th, 2020. If you had 10 at the beginning, you have to have 10 at the end, unless there's an extenuating circumstance, such as your business is absolutely shut down because of COVID, or you've attempted to rehire the people you laid off and they've either refused, or you have put out, job applications, or sorry, job postings. There's been no reply. You just can't find a qualified candidate. Unfortunately, because of the speed in which these regulations have been issued, it has been difficult. It's difficult for me to say how the administrative body, being the SBA, will actually look at the data presented and how close. This is something that I think everyone is struggling with just because of the novel nature of the pandemic. But I think just in general terms, the best bet with the government is to disclose, to be thorough, and you stand a much better chance, I think, of passing muster at that point. And if it takes you a few more months, I think it's worth it to present your best application rather than hurry up. The interest rate on these loans is only 1% if it's denied. I'm not trying to put your money out there in the universe, but I think the upside of taking your time with this far outweighs the downside of waiting a few months to be done with it, especially as lenders struggle to create their own internal mechanism to review the applications, because really the government is asking the lenders to be this conduit to really administer this program. So they're really going to be potentially your best advocate, which is why I suggested starting a dialogue early with your lender on the forgiveness. So, but just remember, if you're over 2 million, it's going to be reviewed by the SBA. And if it's under that, they do indeed have the right to review.
All right. I have a quick question, and I'm going to show my total ignorance of tax law. That's why I'm so thrilled you're here. You mentioned that our legislators are currently debating whether small businesses may be able to deduct expenses for forgivable loans. Is there a timetable, or is there a deadline that they have to hit to make a decision, or is this just an ongoing thing?
So generally, they would want to reach a decision before January 1, 2021, because this is going to affect your 2020 tax filings.
Right.
Now, most businesses are going to take an extension. You're really looking at fall 2021 before you have to submit your tax returns. And just to be clear for folks that aren't tax experts, or send their books to their accountants, nothing wrong with that. Normally, when you're running your business, you have ordinary business expenses that deduct from your bottom line when it comes time to kick off your K1, and the biggest one of those is usually your payroll, right? And then secondary is going to be rent. Working with this is the concept that if you receive a loan, say like a revolving line of credit to keep your doors open in normal times, the fact that you brought $75,000 or $150,000 into your bank account, but have a corresponding obligation to pay it back, the government considers this essentially a wash. Okay, it doesn't actually increase your income. There is a provision in the Internal Revenue called discharge of indebtedness income. They just love to make it as wordy as possible. But the concept is, if someone gives you a loan, let's say $150,000, and then it says, you know what, you don't have to give it back, you don't have to pay it back. Well, that's $150,000 you didn't have before. That's income. That's taxable. So the PPP loans, absent legislative grace, would have been taxable when they were forgiven, and that was the initial issue. People were crying foul. Hey, you want to help us out, but wait, we have to pick this up in income at the end of the year. So that, that $300,000, $500,000 PPP loan, it's not worth that if you have to pay taxes on it. It's worth much less. So what the IRS did, what the legislature did, was put a provision saying that it's exempt from that definition of discharge of indebtedness income. And where it comes around is the idea that, well, you know what, I did have those expenses. Usually the government doesn't care where you get the money from to pay those expenses. Well, the IRS said, and this is the IRS, the administrative body, this is not the legislature, this is not an executive order. This is the Revenue Department taking a position that if you receive money and you don't have to pay tax on it, it doesn't make sense that you could use that money to pay for expenses that then become a deduction on your tax return. And that's that double dip, or 2 bites at the apple, that the IRS is saying, no, that's a bridge too far. Because of the election year, I really can't say what's going to happen, because I certainly think, everyone here, more money in our pockets, the better, right? But the cost of either side of the aisle coming to an agreement right now in terms of political capital, this is outside of my expertise. I think that's why you're seeing a lot of stalling, though. I don't think anyone wants to give an inch. You may see more action if you have a Trump victory in a Republican Senate, because they know they're going to be around for 4 more years. But in any case, I would assume you would see legislative a legislative decision before December of this year. If not, it would be early January or February. I don't think too many business owners are going to be trying to file their returns by January 10th this year, just with all the uncertainty in the world and just how long it takes to get records going. But I would say by early 2021 at the latest, if at all.
Okay.
All right, great information.
Yeah, absolutely. I actually had another question. So as we have a ton of 1099 independent contractors on the call, I was someone who was furloughed and received pandemic unemployment assistance. How are taxes handled for anyone who received that?
Yeah. So that's fortunately a relatively easy answer. That's no different than any other kind of unemployment. It's considered income. It's fully taxable as only ordinary income. The only difference is that the dollar amount went up. That's that $600 extra, but you still have to pick it up in your taxes at the end of the year. So, I'm not an employment law expert, but I certainly know that was that's being debated as adding it maybe $300, $400, or even maybe $600 again back in for the unemployment assistance. And that pandemic unemployment assistance, that PUA, I believe is only limited to people that are not otherwise qualified for unemployment. So that's where the 1099s really come into play. It's different than what they call quote unquote ordinary unemployment. But yeah, it's just ordinary income. There's no corresponding forgiveness of the amount. They wouldn't extend it that far, unfortunately. And if you think about it, though, it makes sense, because the PPP loans, to the extent, let's say I don't know, but if my wages were partly covered by PPP, the fact that those were forgiven doesn't mean that my employer doesn't have to pay payroll taxes on it, FICA withholding, et cetera, because it really is based on your total, your gross pay, and then you still have to do the withholding. So the analogy would continue on, and it would put you in the same situation, in that you have to have withholding, and that's it in that scenario.
Okay, great, thank you.
Do you think that the government's wallet now is clamped shut? I know some reps have asked, do you think there might be any possibility the government gave us additional PUA, or you think the well is dry?
Are you talking about with PPP or unemployment?
With the unemployment, and with both, actually.
Both sides have discussed additional payouts, I guess. I don't know. I guess I kind of hesitate to call it anything else. I believe I'm just going to ballpark it. I know the Senate Republican bill was somewhere in the, hundreds of high hundreds of billions. I believe the Democratic House bill was originally $3 trillion. Last I saw, I thought the Democrats came down to 1.5 trillion, and I don't know if that's the negotiation that's going on. I don't think that there is any doubt, at least from my experience, that and from what I've seen, that America has not recovered. I think, just speaking globally, regardless of party affiliation, things are not back to normal. And I think that Congress understands that. And I think that's the difficulty of it being in an election year, because I think what you're seeing is a hesitation to get relief because of potentially the political consequences. And I don't want to get too much. What I'm seeing is from a purely tax or economic standpoint, a stimulus makes sense. I don't think there's any doubt things are not back to normal. That's just the way it is. And I can, again, only speculate, and I don't want to make anything like this to be political, that because of the election year, you're seeing a hesitation on both sides to really come to the middle, which is unfortunate. But I do think, regardless of the outcome of the election, I think you will see additional relief in early 2021, whether there is a change in the White House or not.
Thank you. This was great. It was good.
Adam, I apologize if that was too much on the political spectrum. It's a really difficult question to answer without discussing.
Right. No, Andrew, thank you for that. Based on the absence of additional questions in the chat room, I think you either exhausted the subject matter or you put everybody to sleep. But either way, thank you for contributing that. Let's move on, Steve, if it's okay. We'll jump to the other questions, the other topics that we circulated. And by the way, we didn't devise these topics. They really came from you. These were suggested to us based on your input to IHFRA. So we're just trying to be responsive here to the topics that I know are of interest to you. And Matt is going to jump in here based on his years as a employment lawyer here in the trenches in Chicago. And you can certainly, I hope, get a glimpse of the Chicago loop out the windows of both my office and Matt's office there. We're back in the office, and Matt's going to deal with topics related to coming back to work. So Matt, whenever you're ready, why don't you discuss some of these health and safety issues that we've been talking
about. Just as Adam said, I'm Matt Terrell. I do a lot of the employment work here, but I also work with Adam and a number of the other attorneys here on sales rep matters. So I have some level of familiarity with the industry and the unique challenges that sales representatives face. And speaking of one, the first topic it concerns dealing with factory come-to-market demands. And given the ongoing pandemic, this obviously raises, I think, serious concerns for independent sales representatives who may not be comfortable participating in this sort of event that may well have been routine in the past, but due to the nature of events like this, with a lot of people in close quarters, a lot of communication, a lot of interaction, and face-to-face contact, there is a heightened risk of a super spreader event, or just transmission or receipt of the COVID-19 virus. And so the question I think is raised is, well, what happens if your principal, your manufacturer, that you are their independent sales representative, says, we need you to come to market? What are your rights? Well, the first question is, what does the contract say between the independent sales representative and the manufacturer or the principal? Ultimately, the relationship between the two entities is largely governed by the contractual promises set forth in their agreement. And if the agreement specifies some obligation to participate in these, in a come to market style event, then that raises an issue of whether there's a contractual obligation to do it. And of course, whether the facts would warrant excusing that obligation based on the COVID-19 pandemic. But I'm going to guess that in the vast majority of situations, a sales representative agreement is not going to be specific to this and maybe silent to it. In which case, there's no specific obligation on the sales representative to attend. However, the manufacturer, if they insist on it, has typically has leverage if they have broad discretion to terminate the sales representative either at will or on short period of notice. So in that sense, although it's not in the contract as an obligation, the manufacturer can still have, or principal can still have that leverage, the termination leverage, to try to encourage participating in these events. So what other tools or ammunition does a sales representative have if they do not want to participate and they do not want to be negatively punished for it? Not very much. But one consideration would be to examine whether the event, the way it's planned, the way it's set up, and the specific aspects of it that the sales representative is being asked to participate in, does it comply with the applicable federal, state, and local regulations, executive orders, which vary considerably from state to state, and they're in a constant state of flux. But if there is a argument that participating in this would not only subject someone to a health risk, but also may violate an existing statute or more likely executive order, there's a much stronger basis for asserting that there should be no basis to require a sales representative to participate. Whether that would prevent the manufacturer from lawfully terminating them in retaliation is a more difficult question, but it is something to consider, and especially if the manufacturer's demand to come to market is asking a sales representative to participate in activity that would be illegal, depending on the circumstances. If one does participate, and that is at the discretion of each sales representative, I think that it goes without saying that adherence to social distancing, CDC regulation guidance, OSHA guidelines, and public health departments in the location where the event is held is an absolute recommended approach, both for protecting the health of the individual and others who you'd be interacting with, customers and employees of the principal and whatnot. So those are some of the issues that involve the come to market demands, and unfortunately, independent sales representatives don't have a lot of leverage there beyond, I think, some of the items that we just discussed. But ultimately, the hope is that people can be reasonable and maybe arrive at compromise in terms of modifying events so that they have added levels of safety and protection, and essentially, have your cake and eat it too. Achieve the same benefit that you would ordinarily have from this sort of event, while also, not subjecting yourself or others to, undue health risks arising out of this pandemic. So I'm ready to move on unless anyone has any specific questions on this topic.
Just a quick one. I mean, I think you've probably covered it, but one thing that was asked more than once was, what happens if I have a pre-existing condition, or I find myself in a higher risk capacity? Does anything change for me?
Well, if you are an independent sales representative, you're not an employee of the manufacturer. In the vast majority of states and under federal law, you would not have the benefit of requesting a reasonable accommodation for a particular health condition. The Americans with Disabilities Act is the federal law, and there are many analogous state laws which provide an employer has a duty to accommodate an employee who has a disability, which could include a serious health condition or something that would put them at a heightened risk. That law does not apply to this sort of relationship involving an independent contractor. Now, some states it does. Illinois recently enacted legislation that extended those protections, traditional employment law statutes, to include independent contractors. Most other states have not gone in that direction, and I don't expect them to anytime soon. But as far as if someone is in a serious, risk category, I think that's something certainly to point out to, manufacturer, because they may not know it. They may not realize. And sometimes, we have to go beyond what, your legal remedies are and look at practical resolutions to these sorts of issues, because sometimes that's the only thing you have left to fall back on. But if pointing something like that out is better than keeping it silent and, being left in a bad position when you don't want to participate and they retaliate against you. I think there's a question here: is which state's laws would apply? Rep location, factory location, market location. Well, I think I just had a flashback to conflicts of law classes from law school. This is an extremely complicated question. It depends on what law was violated. If a Illinois state law provides some protection for representatives who are doing business or have their territory in Illinois, or if the manufacturer is in Illinois and there's protection there, an argument could be made that state law could govern and thereby give rise to a cause of action if the principal violates it. In a situation where the market location, you're traveling, that's a different question. And again, it all depends on what the nature is of the claim that would be asserted, because that's how the courts look at determining, well, do I apply Ohio law? Do I apply Kentucky law? Do I apply, what do I do? And there's a set of criteria that are utilized. But the starting point is determining, what the cause of action is. If it's a breach of contract, breach of the sales representative agreement, in some cases, the agreement may include a choice of law provision that says California law shall govern the interpretation and enforcement of this agreement, and as well as jurisdictional provisions or forum selection clauses requiring where the parties resolve any dispute. So those are some of the things that could come up, but determining what state's law applies depends on a lot of different moving factors that are very case by case specific.
Great, thank you.
So I'm going to move on, if it's all right with anyone else, or unless there's any other questions, to some health and safety issues for independent sales representatives who travel. And as I'm sure many of you or all of you know, independent sales representatives often are assigned to a geographical territory, are often required to travel lengthy distances on the road for extended periods of time. And one thing is clear is that independent sales representatives should make every effort to ensure that their employees or sub-representatives are taking the necessary precautions to benefit their health and safety and avoid risking unnecessary illness or other complication, in the course of their travel. Now, I think that in many employers have policies. Some independent sales representatives have policies beyond just reimbursement and things like that, but specific rules, restrictions, directives, or guidelines as to how to conduct oneself while traveling in order to to maintain and promote health and safety of the individual. Now, the reality is that there's no one size fits all policy that is going to be that I would just send to every one of you. It all depends on the nature of your specific business, the nature of the travel involved, how flexible you have in terms of deciding whether to call on a customer, whether to make in-person visits, whether travel is truly necessary and to what extent. All of that may depend on the nature of the relationships you have with the customers who you deal with on behalf of principals. And so all of those should be taken into account. But what I think every policy with regard to traveling sales representatives or employees should make clear what the specific requirements and expectations are. I think, with regard to COVID-19, if someone, it plans to travel, but it tests positive or experiences symptoms or is exposed and there is a likelihood that they may contract the illness, I think it would be a well-warranted policy to bar that person or restrict that person from, pursuing travel until after they're out of the clear. Not everyone would like that, but those are some of the things that you should consider, not only in protecting your staff, your sales representatives, or sub reps or employees, but the last thing you want to do is have a member of your team go out to a customer and infect them without them knowing that risk was present there. It's not a good result, and it's not something that it's going to make people happy. Another thing that you can consider doing with a policy is making an effort to plan itineraries, travel itineraries in advance, and to make sure that those itineraries, whenever possible, take into account the nature of the rate of infection and the rate of transmission of COVID-19 in various geographic areas. If there's a hotspot and you have 10 customers and you don't have time to meet all 10 of them, and you don't value maybe that you equally consider them equally important, and 3 of them or 2 of them are in a hotspot and the other 8 aren't, it's a pretty common sense way to, as a matter of policy, make the decision on that basis to avoid in-person visits to those sorts of customers. It seems straightforward, it seems obvious, but the way travel can happen and scheduling, and when things aren't done in advance, you may not have the opportunity to do that. So I think that depending on the nature of your sales rep agency, when you have travel plans, do so in advance, and then update those plans and make sure they're flexible to take into account changes. changes that may occur in terms of where there are outbreaks and things of that nature. And I think it's also important that whenever a sales rep is traveling, that not only they're maintaining good hygiene, washing their hands, sanitizing their hands, avoid touching their face, but utilizing personal protective equipment, wearing a mask. Even though some individuals may not like it, they may find it annoying. I think your customer or an employee of a principal may have that expectation, and it may be required depending on what state you're in, or a local ordinance, or just based on the business rules that may be in place. So I think that it is a good practice to take the most restrictive possible precautions within reason and adhere to those. And I think that you shouldn't necessarily have major issues, and you more likely than not will go a long way in protecting yourself as compared with someone who did not follow those sorts of guidelines. And of course, I think just from a purely practical perspective, if you're a customer or manufacturer has their own requirements, temperature every time you enter a location, or face masks at all time, or whatever policies they have in place, make sure you know what they are in advance, because you don't want to show up and inadvertently not be in compliance with a requirement that a particular customer or manufacturer has that may not exist in other circumstances. So that's all part of, I think, the planning in advance meticulously, because it's just good customer and business relations to make sure that you're adhering to what their policies are and respecting them. There was one question about the face mask requirement. If there is an obligation to wear a face mask under whether it's a customer policy or manufacturer policy or the sales representative agency's policy. Well, what if an individual has asthma, such that wearing a face mask could exacerbate the condition or make it more difficult than ordinary to deal with a condition like that involving breathing. And this is similar to what I discussed before, is that there is no right of an independent contractor to say, I don't have to comply with a principal's mask requirement due to something of that nature. By contrast, if it's an employee-employer relationship, so if a sales rep agency has employees and not 1099 contractors, and an employee has a condition of that nature, there may be a duty to provide a reasonable accommodation, some means of finding an alternative way for the individual to work to the extent it can be reasonably done in a manner that does not require them to utilize a mask, but at the same time achieves the objectives that mask wearing is intended to prevent. So maybe that's working remotely, or maybe isolated workspace. It could be, altering or staggering schedules. So those are all sorts of things that on a case-by-case basis go into the reasonable accommodation analysis under the ADA that employers are obligated to follow with regard to their employees. And it's something to consider, for any sales rep agency that has employees. If you have more than 15 employees, you're covered by the federal law. And in most states, there are analogous laws that cover even smaller businesses with less than 15 employees, such as Illinois, which covers any business that has at least one employee. So that's pretty much everybody. Are there any other questions, regarding this topic?
Andrew, it's less of a health and safety, but it's more of a question about reps getting back on the road. I've been asked this by 3 different reps, and I'm glad you guys are here to feel this. The question has been, since COVID, factories are insisting that some of our members keep very detailed reports of where they've been, who they've seen, what they've discussed. And the story I'm getting from the reps is, we never had to do that before. This is just post-COVID, and it's burdensome. Are we obligated to kind of handhold and give those reports?
Well, I guess this goes back to, well, what does your contract provide? I'm pretty sure that no one's contract had any idea this pandemic was coming, so I doubt that any contract speaks to it. But I do think what you described as that level of detail seems to me to be over the top. In any other circumstance, the inquiry is, have you tested positive? Have you been exposed to someone who's tested positive within, the incubation period or the recovery period, or have you experienced symptoms? Now, there is a consideration about traveling to particular locations. In Illinois, for example, if you travel to certain states that are listed as having a higher prevalence of infection, there's an obligation that upon return you have to quarantine for 14 days. So, to that extent, if you're wanting to know where was someone traveling from, I don't think that's unreasonable. But I do find it somewhat unreasonable to be demanding the level of detail that you're describing, which to me almost seems to get into, your proprietary information or things that may otherwise be confidential, customer contacts or things like that. Exactly. Especially if you work with them on, with other lines, if you represent multiple lines. But there's no law against what you're describing.
All right, good. Thank you.
There's no law
against it.
Matt, let me jump in for a second, because while there's no law, there is, of course, an industry standard, and asking sales reps to submit any kind of call reports or other attempts to track the sales rep's time and effort spent on behalf of a particular supplier are, in my humble opinion, unholy. And, you're right, there's no statute that says they can't do it, and almost no written contract, specifically describes that either. But most of the folks in this session, are working off of oral contracts. So there's certainly no requirement that the rep has ever agreed to that said he would spend his time filling out reports instead of going out into the field, where principals typically want them to be, and knocking on doors and generating demand for the products. So I think this is it can be an attempt to get information in the COVID era that perhaps wasn't so readily obtainable pre-COVID. And I'd hate to see COVID used as a pretense to get the kind of reports that would not otherwise have been on the table. Sure, they have some legitimate interest if it's from perhaps a contact tracing perspective to find out something about calls. But any attempt to get the rep to account for its time or the number of visits, that smacks a lot more of a employee rather than an independent contractor. And I don't like it one bit.
That was their concern. Thank you.
I think that's a great point, especially where you delve into the gray area of an employment relationship. And I think, principals do not want to do anything that would, result in legal recognition of an employment relationship when an independent contractor relationship is what is intended. But those are precisely the sorts of things that the law looks at in determining, whether there is actually an employment relationship, because the primary factor of many, but the primary one is the extent to which the principal exercises control over the worker. And, what you're describing is, goes beyond what is traditional and independent contractor relationships.
I have one last quick question. Do I have a case? I have writer's cramp from you guys. Will you represent me? No.
Yeah.
Okay, take it away.
Yeah, well,
This is good.
Yeah, and
Great
just again, we're just about out of time. We're trying to be respectful of everyone's time today, but this has been just incredibly informative and helpful. And just on behalf of IHFRA and our team, we wanted to thank Adam, Matt, and Andrew for their time and expertise. And just to all of our members out there, this is part one of a two-part series that's taking place. So part two is happening on November 11th at 3 p.m. Eastern time. So there's still plenty of time to sign up. I'll be pushing out some links on how to do that soon. Regards to today's webinar, we did record it. So I've already been asked, will this be available later? It sure will. We'll post it on our website. But just in the effort of keeping this short and sweet, November 11th, the next webinar topics are going to include recovering commissions under contracts, written and oral, state sales rep protection statutes, other extra contractual recovery methods, post-termination commission recovery, and more. So just be sure to sign up for that webinar. Again, thank you, Adam, Andrew, Matt. We couldn't do it without you. It's a wealth of information that you guys shared with us. And I just wanted to quickly thank everyone who took the time to join in and listen. So
Thanks for having us, Steve. We'll look forward to being with you again next month.
Perfect. Thank you.
thank you, everybody. Hope you all have a great day.